So Mr. Waikian holds several professional credentials and memberships, such as Fellow of the Chartered Institute of Arbitrators UK, Fellow of Malaysian Institute of Arbitrators, member of the Royal Institute of Chartered Surveyors UK, and a registered consultant quantity surveyor with Board of Quantity Surveyor Malaysia. He is also empaneled as an arbitrator, mediator, and educator with the Asian International Arbitration Center, and he is also a certified mediator with the Malaysian Mediation Center, MMC. He is currently serving as the Vice President with the Malaysian Institute of Arbitrators and a disciplinary committee member with the Advocates and Solicitors Disciplinary Board. It is my pleasure to introduce Mr. Waikian this evening to give us a talk on the difference between arbitration and litigation. Go ahead.
Okay, thanks, Harry. Hi, good evening, everyone. My name is Waikian. So before I start, let me share my screen. Okay, I just want to check if you all can see my screen.
Yes, ma'am.
Okay, sure. So, okay, good evening, ladies and gentlemen. My name is Waikian, and I must say I'm very excited to meet all of you in this webinar tonight. First and foremost, I would like to thank the Rotary Club of Sungai Petani for having me here tonight to speak at this webinar. So tonight we'll be looking into a topic which may impact businesses and individuals such as you and myself. And tonight I'll be sharing on the distinction between litigation and arbitration. What's the difference? So let us move on to explore further on this topic. So I believe Harry has actually introduced my background earlier, but just let me run through a very quick background of myself. Again, my name is Waikian, Chartered Quantity Surveyor. I have 17 years of experience in the construction and also the dispute resolution field. Holds a Master in Quantity Surveying, Bachelor of Jurisprudence from University of Malaya. My expertise will be in the expert witness field and construction claims. Affiliated to the Chartered Institute of Arbitrators, the Royal Institute of Chartered Surveyors, both UK and Malaysia, and also I'm a registered consultant quantity surveyor with the Board of Quantity Surveyor Malaysia. I'm also a panel arbitrators, mediator, adjudicator with the AIC, currently serving as the Vice President of MIR, and also a disciplinary committee member with the Advocates and Solicitors Disciplinary Panel Board. Okay, so in this presentation, I'll be covering 7 crucial segments on this topic. Here you can look at the contents. I will start with the introduction of the fundamental concept of the dispute resolution. Okay, setting the stage of a detailed comparison between litigation and arbitration. Then we'll move on to the litigation and arbitration. What are they? Here we will define and discuss the key characteristic of both litigation and arbitration. On the segment of structural and procedural differences, we'll be comparing the differences between the framework and the processes of litigation and arbitration. I'll also talk about the cost and time comparison, who are the decision makers in the litigation, in the arbitration, and also touch on the flexibility and control, the enforceability between the litigation and arbitration, pros and cons, and finally the conclusion, where I will summarize what we have discussed in this webinar tonight, and also try to conclude key takeaways for all of you. So now let us move on into the first segment of tonight, the introduction. Okay, let us start our session by acknowledging a very simple fact. You cannot avoid dispute in business or in our daily life. Okay, so some of you might disagree But the reality is that the times have changed and people are no longer friendly as they were during the 70s or the 80s. So one of the reason might be because social pressures and competition for better living, which actually leads them to have a higher stress level and also less patient. Hence, they have less tolerance in terms of dispute. Hence, that is why the reason of increasing disputes. So disputes may arise in various industry, especially in industries such as the construction, the medical, the accounting. So each field has its unique challenges, and the impact of this dispute can be very significant. So in understanding the differences between the various dispute resolution is essential. So why? Because choosing the right approach can save time, it reduce costs, and also it preserve relationship. So as you can see here, resolving disputes are not limited only to going to court. There are other methods such as arbitration, mediation, adjudication, and expert determination, and there are other more. Okay. However, tonight we will only be touching on litigation and arbitration. For the rest, we'll leave it for some other time. So now I'll move on to the first segment of tonight. So what is litigation? So I'm sure all of you have already know about this. So in the context of Malaysia, litigation refers to the process of resolving disputes through the formal court system. So in layman terms, we say going to the court, or we are going to sue another person, XXX, Mr. XXX, or what. So that is the general terms of litigation. So essentially, it actually involves parties bringing their disputes or their conflicts to a court where it will be decided by a judge by hearing the evidence and arguments from both parties. And finally, they are making a legally binding decision. Okay, so in litigation, it is often characterized by a structured procedures that includes filing and responding to complaints, conducting discovery, which is the exchange of relevant information and documents, presenting the case in trials, and potentially appeal against the court decision. So the Malaysian legal system is heavily influenced by the British law, which actually explain why and how it has provided a very comprehensive framework for the litigation. And this process it used to resolve a variety of disputes ranging from contract breaches, property dispute, and sometimes the personal injuries cases as well. So the decision actually made by the judge are legally binding on all parties. So here, at the end of the day, the court system or litigation are there to ensure the disputes are settled in a fairly manner and also in accordance to the law. So let us quickly look at the characteristic of litigation. So first characteristic, it is a formal mechanism used primarily to resolve dispute. And this process takes place in a court setting where both parties will present their case. Second characteristic, they are bound by strict procedural rules, okay, to ensure that the process remains structured and consistent. So it will allow for an orderly presentation and consideration of evidence and also arguments. Okay, third characteristic, litigation involve the decisive role of a neutral judge, or in some cases, jury, who will ultimately render a verdict. And finally, an important aspect of Malaysian litigation is transparency. So, except in certain cases, court records are actually public, which means that they can be accessed by the general public. So, this transparency will help to ensure that the proceedings are fairly and that justice will be seen to be done. Moving on. Now, we have looked at litigation. Now, what is arbitration then? So, if litigation involves the public court, arbitration, I would say it is like a private court. So, sorry, my slide's not moving. Okay, so in a nutshell, the arbitration is form of an alternative dispute resolution, or we call it the ADR, where disputes are settled outside the court, okay, by one or more arbitrators appointed by the parties. So it is a private process that is often chosen for its confidentiality, the speed, and also the expertise of arbitrators in the specific fields. In arbitration, both parties will agree to submit their dispute to an arbitrator who will make a decision after hearing arguments and reviewing evidence from both parties. So the decision made by this arbitrator, we call it the award, is usually final and binding. What it means is that it is enforceable the same way you can enforce it like a court judgment. And there are very limited grounds on which it can be appealed, unlike the litigation where you actually can appeal against judgment by the court. Sorry, I'm also having some technical glitches here because my slides is not moving. I'm sorry, can I just check whether my slides are moving from any of your side?
Now showing flexibility. Yes, moving.
Now it's moving. Okay, sorry. So, okay, I think I just stopped at the decision making, I guess. So now I will move on to the advantages. So one of the primary advantages of arbitration is confidentiality, which means that it protects the reputation and sensitive information of the parties involved. In terms of flexibility, arbitration allows parties to customize their process, okay, due to their specific needs. So the parties are actually free to decide on the timing, the procedures, the rules, the law governing the arbitration process. Okay, now we'll move on to the characteristics of the arbitration. So in short, it is a private process to resolve disputes. Okay, so unlike court cases, which are typically public, arbitration allows party to resolve this dispute in a very confidential manner, which can be crucial in maintaining their business relationship as well as protecting some business secrets or the trade secrets. So it is less formal than litigation. Arbitration allows the process to be more responsive to the needs of the parties involved. Parties are free to decide on the rules and procedures of the proceedings. So it can involve in one arbitrators or a panel of arbitrators, might be sometimes usually will be 3 arbitrators panel. And unlike litigation which are public, these arbitration proceedings are confidential, which means that they are not open to the public, and the detail of the case will remain between the parties involved. So these are the characteristics of arbitration. Now we'll explore the key differences between litigation and arbitration. We'll look at their structure and the procedures of litigation first. Okay, so in litigation, basically it is court-based, which means that litigation is tied to the court system. So it takes place in a formal judicial setting, okay, following the legal standards and the process of the court. Rigid procedural rules, the procedures in litigation are defined by the legal framework and court rules. So they are a bit more rigid, and in a way, you need to be strictly follow the rules, leaving little room for flexibility. Publicly accessible litigation proceedings are public. So this transparency ensures that the process is visible and accountable, which can lead to public exposure of sensitive information. So for arbitration, on the other hand, okay, it is more private, flexible procedures and confidential. So unlike litigation, arbitration is a private process. So the setting not only ensure confidentiality, but also it actually allows the party to involve more control over the proceeding. So it provides more flexibility. Parties they can negotiate on how the arbitration will be conducted, including choosing a much more simpler rules of evidence and procedures, which can lead to a more efficient process. So like I mentioned earlier, confidentiality is one of the key advantages of arbitration, which means that the proceedings and the final decision are not open to the public. So this privacy is actually beneficial for preserving, again, the business relationship and also protecting the trade secrets for some business entities. So in short, litigation is actually structured around a formal court system, okay, with a predefined rules and public proceedings, while arbitration, on the other hand, it offers a more private, a more flexible alternative that can be tailored to the specific needs of the disputing parties. Now, so in terms of the cost and time comparison, litigation can often be more expensive than arbitration. This is perhaps due to several factors, including the longer duration in court, the need for an extensive hearing, and also the higher lawyer fees due to the prolongation of the litigation process. In terms of time, it is much more time consuming because it is bound by a formal court schedules and the procedural requirements, which can lead to prolonged cases. So in terms of the indirect costs, there are also consideration for this due to the public exposure, because the court proceedings are public. So this may lead to a reputational damage if sensitive or damaging information it will be disclosed during the process. So in terms of the arbitration, is less expensive. I put a double question marks there. because I'm also not so sure, because sometimes arbitration might be expensive, and sometimes it is even more expensive than the litigation due to several consideration. One of it will be the number of arbitrators that you're going to appoint in your case. Secondly, will be the location of the arbitration. For example, if we are going to have the hearing of the arbitration in other countries such as Singapore, Hong Kong, UK, so perhaps the travel expenses itself is killing. Whereas litigation is basically are all the hearing will be conducted in the local courts, okay, which are all domestics. So in terms of time, okay, I must agree that it is definitely a quicker solution because the procedures are much more flexible. So it will allow more expedited resolution of disputes. Privacy-wise, yes, it is also protected from public exposure because it is conducted in a private settings. So all these sensitive information and also the decision actually will be kept between the parties. So now we'll look into the key figures who play a key role in the decision-making process. So as you all can guess it, litigation will be the judge, okay? And in some cases, jury. So in litigation, these decisions are definitely made by judge, okay? The judges are appointed based on their legal expertise and also their experience to ensure that the law is applied correctly in each case. So in countries such as US, UK, a jury can be also involved in the decision-making process, okay? The juries are actually composed of the citizens, okay, which are responsible for assessing the facts and of the case and then make a decision based on the evidence presented to them. Malaysia has the jury system previously, but it was abolished somewhere in 1995. So now we no longer are using the jury system in Malaysia. Okay, in arbitration, on the other hand, the decision makers are quite different. Here, the parties involved, they have more control on who's going to decide their case. They can appoint an arbitrator, okay, a solo arbitrator, one person, or they can appoint a panel of arbitrators, more than one person, usually three, which who are typically chosen for their expertise in a particular field in relation to the dispute. So in the context of construction, usually the architects, engineers, quantity surveyors are appointed as the arbitrators due to their technical knowledge and their expertise in some particular dispute areas in the construction. But then it actually, in other few areas as well, the other experts such as the auditors or in the doctors in specific line of expertise might be also appointed as the arbitrators for their own respective disputes. So in both systems, the decision makers, it plays a very important role in shaping the outcome of the disputes. Whether it is a legally trained judge or whether you want to have an expert in some technical issues. So this will actually will be some of the key consideration when you are deciding on which choice of dispute resolution method are suitable for you. Okay, now we are at these segments which I term it as the flexibility and control. So let's look at the litigation. Okay, so in terms of litigation, it has limited flexibility. It also limits on how parties present their case. litigation are usually bound by legal precedent, decided cases, and there's a strict legal rules. So in litigation, flexibility is most of the time restricted. The process is bound by the formal court procedures and the rigid framework of the judicial system. Although I see the rigidity as good because it provides consistency, but sometimes it can be also a constraint. And also parties have limited freedom on how they are going to present their case, unlike in arbitration. So litigation also is bound by the legal precedent, means that the judges are bound to follow previously decided cases, which can limit their discretion in deciding in a specific case. And in terms of the legal rules, the entire legal litigation process is actually governed by a very stringent legal rules, which dictates every aspect of the proceedings from filing up until judgment. Okay, in terms for arbitration, it is more flexible, where parties can decide on the process, okay, the rules, who are the people that are going to decide on the cases, which is the arbitrators, and also on the timeline as well. It allows customization by the parties, so the parties will have more controls in the proceeding as compared to litigation. Okay, so now we'll look into the enforceability of between litigation and arbitration. So decision made by the judge is called a judgment, enforceable by law within the jurisdiction where the court is located. The enforcement mechanism is actually quite clear and straightforward. So legal mechanisms are in place to ensure compliance, such as liens, garnishment, or other court orders. Okay. In terms of enforceability in other jurisdiction, it really depends on the treaty signed between the countries. But in terms of the local aspect, it has no issue in enforcing in the domestic context. Okay, for arbitration, the decision made by the arbitrator is called an award. It is the award is actually legally binding and enforceable court or in other places in other countries as well. So these are actually governed by the Arbitration Act. Okay, here. So here, the award is actually internationally recognized. Okay, and it is easier to enforce globally than litigation judgment. So this is all thanks to the New York Convention on the recognition and enforcement of the foreign arbitral awards. So this convention has wide international support, and the enforcement of arbitration awards, it can go across the borders. So as long as any countries are who are the signatories of this New York Convention, that country itself will recognize the arbitration awards produced from the signatory countries. For example, if the arbitration awards are made in Malaysia, it can be recognized in Singapore, Hong Kong, UK, or any other countries that are the signatories of this New York Convention. So now we will just move on to talk about the pros and cons of litigation. So some of the pros of litigation is that they set a very clear legal precedence and clarity. It governed by the established laws. Okay, so it can provide predictability and also consistency on how these legal issues are going to be resolved. Okay, public record enforceability appeals possible. So public record, the proceedings and judgment are public, which can defer the wrongful conduct and ensure a level of transparency that upholds the public trust. In terms of the enforceability, judgment are actually legally binding. So it backed by the state enforcement mechanism, so make it easier to enforce domestically. Okay. Appeals possible means that there's a appeal process. So it provides opportunity for an appeal, offering a safety net, okay, for correcting errors if there's error in the initial trial. In terms of the cons, okay, the cost, it is time consuming, it is rigid, and adversarial nature is bad for relationship and business. So litigation, like I mentioned earlier, it can be very costly because of uh, the the prolongation of the case. Okay, and some complex cases it may drag for years. So the financial burden will be definitely on the legal fees, the court fees, and other expenses related to the case. Time consuming, as mentioned, the process can be very lengthy because of the procedural formalities, and also because it is crowded by the court schedules, and also potential for multiple appeals, which can further delay the um, final resolution of the case. Rigidity, the strict procedural rules leave little room for customization of the process, okay, and always not serve the best interest for both parties. And finally, the adversarial nature of the litigation. So it might be bad for business, as it will strain the relationship between the potential clients and also for the businesses as well. So in short, litigation is actually a much more robust system for dispute resolution, okay, because it offers clarity and enforceability, but the drawback will be it is very time consuming. So it is best suited for dispute where legal precedent, transparency, and the possibility of appeals are important. So for those considering litigation, uh, you can weigh the pros and cons as shown here. So for arbitration, what are the pros and cons? Okay, so in short, the pros will be the speed, cost-effective, confidentiality, expertise of arbitrators, and flexibility. So all these things are actually the key advantages of arbitration. Arbitration is typically faster than litigation because of the less stringent rules and procedures. Okay, the parties, you can decide in a more simpler rules and laws. Okay, which actually can make the things much more effective and actually much more faster. Like I say, cost effective, I'm still quite skeptical because it really depends on case to case basis, how many arbitrators you'll be using, the location of the arbitration, and also the legal counsel that you're going to engage in the case. Confidentiality, no doubt about that, it is confidential in terms of the decision made in these arbitration proceedings. The expertise of arbitrators, yes, you can choose the expertise that you think that the parties think that are suitable in the disputes among them. If there's a medical disputes, perhaps some specialist doctors can be engaged, okay, to be the arbitrators with the required expertise to decide on the cases. Okay, some of the cons of the arbitration will include the limited right of appeal, potential for high costs, okay, as I mentioned earlier. The variables quality, okay, due to the different background of arbitrators. even though you're choosing from the pool of architects, but different architects might have the different qualities and also standards in deciding the cases. So there will be no standard, no set standards in terms in that sense. Lack of transparency because it is confidential. So there's always a concern about fairness, whether the arbitrators has decided in a fairly manner. So yeah, these are some of the cons of arbitration. Okay, now we have come to the finale of tonight, the conclusion. So here, now I will be concluding some of the key points that I have touched on earlier. So, okay, litigation is a formal process, okay, while arbitration is private. So litigation, as mentioned, is a bit time consuming as compared to arbitration, which is much more faster. Decision makers in litigation are judges. Okay, arbitration, they are the arbitrators with the chosen expertise, and flexibilities and control of the parties involved actually will be much more biased a bit to arbitration. The enforceability differs between litigation and arbitration. Arbitration, on the other hand, is actually much more recognized internationally in terms of New York Convention. Litigation, it is also okay in terms of the enforceability in certain countries where they have a treaties agreement. So in summary, I would say there's no definitive conclusion as to which dispute resolution method is the best, as ultimately the choice of the dispute resolution will really depends on the specific needs of each party. So and also what would be the expected outcomes, the timing, and most importantly, what would be the cost. Okay, so based on these factors, you need to think and carefully strategize the approach to the disputes accordingly. So I guess with that, I will end my presentation, and I will just pass back to the floor to the host. So thanks again, everyone. And yeah, I'll pass back the floor to Harry.
Thank you, Mr. Wei.
Yeah.
Okay.
Yeah.
Can you hear me?
Yes.
Okay. Okay. Any question from the floor? Yes, Rizwan.
If there's one issue on both sides, then
Can you hear?
I hear echoes. I couldn't hear. Is it Gopal? That's
You hold first, eh?
okay.
You connect, you on. Hello? Go ahead. Hello? Can you hear me?
Yes, for now. Okay, now it's okay.
Okay. If there's one issue on both sides, can use arbitration as the decision maker, can have the decision, but still get unsatisfied on one side.
Sorry, sorry, I think the echoes is a bit. Yeah, sorry. Sorry, I cannot hear you very clearly. I need.
Rizwan, I can't hear you.
Rizwan, bisa na to? So,
Yeah, sorry, there's a very heavy echoes. Yeah, I couldn't very clearly hear the gentleman's that is speaking just now.
Okay.
hello, sir.
Yes, yes. Okay.
If have one issue on both sides, then use an arbitration as the decision maker, then have the decision, but still have unsatisfied on one side. Can the unsatisfied side take the further action to litigation?
Okay.
Meanwhile, the early decision is already made by arbitration. The litigation is above either than the arbitration decision.
Okay. Sorry, before that, will it be okay for Gopal to mute his mic?
Yeah.
Because yeah.
Okay, go ahead.
Okay, thanks. Okay, so I think to answer to the question to the gentlemen there. So once the arbitrators has decided in these arbitration proceedings, right? So there are very limited situation where you can really challenge the decision by the arbitrators. But there are some grounds where you can challenge due to because of the breach of natural justice, and also due to some of the procedurals uh, unfairness. So might will be some of the grounds that you can challenge them, but you cannot challenge because you do not agree that the arbitrators has decided wrongly. So the threshold or the bar to challenge the decision made by the arbitrators is a bit high over there. So it's not that, because the reason why both parties submit to arbitration is that both parties agreed their case to be finally decided by by one person or by a panel of arbitrators. Okay, but if the aggrieved party later on are not satisfied with the result and they bring it to the litigation, then it will not bring a finality to the arbitration process. That is firstly. Secondly, it will actually cost you even more, the parties even more monies, okay? Because you already spent so much money in arbitration, and then you need to spend another sum of money for litigation as well. So yeah, I hope that will answer your question.
Okay. Any other question? Mr. Wei, just to add on to Rizwan question.
Okay.
Uh, there is one case which I personally experienced where I went to arbitration.
Okay.
I won the case.
Mm-hmm.
Then we call the party refused to pay me.
Okay.
Then I have to go to we call the judgment, the arbitration award. We have to go and go for High Court. We have to register under High Court. Am I right?
Yeah, correct. You need to enforce it. So you enforce it
Enforce
at the High Court. Yeah. Okay.
Even then, because you don't want to pay, you challenge.
Okay.
Then we call. Then I have to engage a lawyer to fight. I won the case. Then he go for review. Even
Okay.
in review, I won the case. He go to a federal court.
Okay.
Until we call federal court also, I won the case. Then he go for review. The review also I won. Then only I can, or we call enforce to go winding up and all those things. Then only he paid me.
Okay.
My question here, because even the arbitration, we go for arbitration. It's not something like a final. We have to go to a litigation again.
Mm-hmm. Okay.
So I feel like is it waste of the time, waste of time, if not we go, we have to back to litigation.
So Mr. Tiago, just to ask you whether the opposing is actually a local Malaysian company
Local
or
Malaysian.
local Malaysian company, right? So usually local Malaysian company, I think you will sometimes you have these kind of issues because you get to challenge the decision. But I think that is actually because of the lawyers, okay? So they have some tactics, okay, to present to their clients, okay? Are you going to challenge it even like after get it? Okay, I'm going to appeal it. So therefore you see just now where as I mentioned litigation, there's a process where you have the appeal process, but in arbitration you have no. So in terms of like I said, if it's international, it will be much more straightforward because you can enforce it at the jurisdiction at the different countries. Once they see the arbitration awards, they will recognize it and they will enforce it. So after that, you can perhaps they can liquidate the what do you call it, the assets of the other parties. But in Malaysia wise, there are actually quite a lot also successful cases using arbitration. And also there are some cases like yourself also. I would say this is kind of like a tactic by some of the the parties
Legal
who
advisor.
yeah, they try to avoid the law by abusing the the loopholes of the legal system. So I wouldn't say that the arbitration is actually a foolproof thing, but in terms of technical issues, yeah, sometimes the parties will prefer someone who has a better technical knowledge to decide on their cases. But if it's about the contractual matters and so on, I guess it is best to just go straight forward for litigation because that will be much more faster rather than, you spend a sum of money in arbitration and then you have to go back to litigation. Is your case earlier is a bit more technical, or actually it is a commercial dispute such as the contractual matters?
It's a claim method.
Oh, okay.
It's a claim, we call progress claim. They don't want to pay, so then I have to go to arbitration.
Construction claims, is it?
Yeah, construction claim.
Oh, okay.
That was a progress claim, and now I got a final claim also. I don't know how I want to go about it.
I see.
Whether I want to go litigation or arbitration again. But
So sorry, is your progress claim? So means the construction is still ongoing or actually is completed?
now it's already completed. But what we call I stopped when they didn't pay me the progress claim.
Okay.
So I stopped and I already proceed with the final claim.
I see. So means actually the construction progress is still not complete yet, but because they didn't pay you, you stop the thing. So
Yeah.
if that's the case, I guess if you want a quick resolution to that, I would just propose you might consider going for SIPA, the adjudication. So usually that happens before the end of the construction. If there's a dispute in terms of the construction progress, right? You can just you can talk to your lawyers. Maybe they can start to initiate SIPA. That actually will be a much faster way to get your money. Usually it takes about 3 to 6 months time as compared if you want to go for litigation or if you want to go for arbitration. But also there are also
Also, I
some
got a case because where they still don't want to pay, I have to go to a court, and it's prolonged.
Yeah. So I guess it is really matters of choosing the right method to get back your money. So usually I mean here in KL, so usually like for progress claims, the contractors will go for SIPA because it is much more faster. So sometimes once they get the decision which is in favor of them, they can just enforce it in court, and sometimes it will give the pressure to other parties to pay. But some of those we call it the hooligan types of contractors. So they will try to drag on, yeah, and they will play lots of kinds of tactics. So they will go to litigation and so on. They will challenge it, yeah.
Talking about SIPA and arbitration in Malaysia, KLRCA, isn't it?
AI, now it's called AIAC.
AIAC.
AIAC, yeah.
So actually, this body is we call to help the contractors, or their is it their business as a AIAC?
Okay, I wouldn't say they are there to help in a way that they are there to help you to facilitate the proceedings. So right now you want to start a SIPA against contractor A. You go to AIAC and register their case. They will give you an adjudicator to decide on your case.
Because in my case, because I got experience where we do SIPA.
Yeah.
The other party, we call not really because they have to pay money. At the end
Okay.
of the day, the result come, the AIAC don't want to release the result due to the other party didn't pay. So I have to pay on behalf to get the result.
Yep. But once you paid for the thing, right? Actually the cost, the adjudicator will actually if it's in your favor, they will decide the cost on your side. So means the other party will need to pay the cost in your award. They will stated in your award that the other party cost that you have paid will be reimbursed back to you.
Okay. So
Yep.
any other question, please?
No.
In Zoom, Mr. Saguru, Tamu,
No.
no
Thanks,
question.
Nothing.
Okay. Okay, Mr. Wei, I think we already come to the end.
Okay.
So I would like to call Harry again for a word of thanks.
Okay. It's very interesting talk, Mr. Chong. Yagu has a lot of questions because he's in the construction industry. So does Mr. Rizwan. So we learned something new this evening, and on behalf of the members of the Rotary Club of Bandar Sungai Petani, we would like to extend our heartfelt thank you and gratitude for your talk this evening. And next time when you're free, please come and visit us on Wednesday night at Park Avenue. Thank you. Thank you so much.
Okay. Thanks, Harry. Thanks everyone. Thanks for everyone for having me tonight. Yeah. So yeah. So I guess I say I think that's about it, is it, Harry?
Yeah.
Yes.
Okay. So thanks everyone. So I see you guys again. Bye-bye.
Bye.
Bye. Bye.
Thanks, Ken Chong.
Yeah, thanks.
Bye.
Thank you.
See
Bye.
you. Bye.